I'm Daniel Levine, and this is the Bio Report. RICO, the Racketeering, Influenced, and Corrupt Organizations Act, may have been created to tackle mobsters, but today it's at the center of a landmark class action against two of the world's largest pharmaceutical companies over the diabetes drug Actos. Attorney Harrison James of Wisner Baum discusses Painters and Allied Trades District Council 82 Healthcare Fund v. Takeda, a national civil RICO class action alleging that Takeda and Eli Lilly engaged in a coordinated, years-long scheme to downplay known bladder cancer risk, misleading regulators, physicians, and third-party payers who reimbursed billions of dollars for the drug. James discusses how RICO's concepts apply in the pharmaceutical context, what it took to get a civil RICO class certified where others have failed, and the broader implication the case may have for the pharmaceutical industry. Harrison, thanks for joining us.
Thanks for having me on. Appreciate it.
We're going to discuss a RICO class action against Takeda Pharmaceuticals and Eli Lilly, the significance of the case, and what the path forward for the litigation is. RICO is a 1970 federal law originally created to target leaders of organized crime. What exactly does the RICO statute say?
That's a good question to start things off. So at its core, RICO, which stands for the Racketeer, Influenced, and Corrupt Organizations Act, it prohibits conducting or participating in the affairs of an enterprise through a pattern of racketeering activity. Now, what does that mean? Racketeering activity, it's specifically defined by the RICO statute, and it includes a big list of what are called RICO predicate acts. The most common predicate acts that are used are mail-in and wire fraud. Those are specific federal crimes where if you're doing fraud over, crossing interstate lines using the mails or using internet, you're going to be swept into mail and wire fraud. So those are the ones that are at issue here. The pattern element, it requires two related acts over time that amount to or pose a threat of continued criminal activity. So basically, it can't be like isolated incidents. There actually has to be some sort of pattern. And it has to be there's an enterprise involved. It can't just be, one isolated criminal actor. There has to be some sort of ongoing concerted activity between different individuals or two different entities acting together over time.
And how did the statute expand beyond organized crime?
Yeah, that's a good question. So the expansion really comes from, I'd say, how Congress wrote the statute and how courts have interpreted over time. So on the face of the text, there's nothing in the statute itself that says, hey, we're narrowly confining this to combat organized crime. The language is very broad, and the courts have consistently applied it, recognizing there isn't any express limitation to the scenarios in which it can be used in. They, interpret the text of the statute quite literally. And if there are facts that fit the types of, elements that are laid out in the statute, the courts have applied it. So they've expanded into other areas, I'd say like securities fraud, insurance fraud, healthcare, where you have these sorts of large-scale schemes that can be carried out through centralized decision-making and repeated communications. And again, it doesn't matter if the business activity, if you're, these are legal business enterprises in a regulated industry, as long as you're doing that sort of concerted fraud in an enterprise, it doesn't matter that it's a otherwise legitimate business or legitimate business activity. So that's kind of how it's naturally expanded over time.
There has always been a civil provision in the law, and the Supreme Court has interpreted those civil provisions broadly. Can you give some sense of past civil RICO cases and where the statute's been applied?
Yeah, that's right. There's a civil provision that, gives rise to a private right of action where if, you were harmed in your business or property by reason of a RICO violation, you can bring suit under the statute. And so I mentioned kind of like, in the commercial financial context it's been used. So I mean, courts have allowed civil RICO claims involving securities fraud, banking schemes, insurance practices where companies were alleged to have used standardized communications to mislead customers over time. In healthcare, it's been used in civil RICO. Cases involving fraudulent billing, kickback arrangements, schemes to misrepresent eligibility for reimbursement. It's been used there. In the pharma space, civil RICO has been used where, plaintiffs have alleged that companies engaged in coordinated efforts to misrepresent or conceal material information. That's the case I'm working on that we'll be talking about later involves that sort of thing. So, throughout these cases, the Supreme Court has repeatedly rejected attempts to narrow the language and the application of the statute through judicially created limitations. And it's really quite remarkable. I mean, through time, there have been all of these Supreme Court decisions where, like the 2008 Bridge case, where it was a unanimous decision and was authored by Justice Thomas, where, they made clear that, this statute has broad application.
Treble damages makes civil RICO actions attractive to plaintiffs. But while that's a big issue, there are other aspects of RICO actions that plaintiffs like. Can you explain what these are and what they allow?
Yeah, that's a good question. And just for the audience's sake, treble damages, that just means essentially tripling. So RICO is you're talking exclusively about economic damages. And so, conceivably those can be calculated in some ascertainable way. What it means is if a plaintiff is successful and you get a verdict and you calculate those economic damages per statute, and the judge doesn't even have discretion in this, that amount is going to be tripled. So obviously that is one thing that makes it an attractive tool to use. Another important aspect is fee shifting. Civil RICO allows a prevailing plaintiff to recover attorney's fees and costs. And that's important because, these cases they're really document intensive. They're expensive to litigate. And it helps ensures that parties who've suffered relatively diffuse or distributed economic harm, like in this case that we'll talk about, it's a class action that's a bunch of third-party payers that were harmed by the RICO conduct. It makes it such that they can actually bring claims when that misconduct is large scale and coordinated. I'd say another thing is nationwide service of process and venue flexibility under the statute. It makes it easier to bring these types of cases. And then there's some key differences in how the Supreme Court has interpreted the statute that make it different from your traditional common law fraud, where you actually have to show that the plaintiff relied on misrepresentations from the defendant. It's a little different in the civil RICO context. You don't really have to show that direct reliance. The focus is more on whether the economic injury was caused by the racketeering, irrespective of that individual reliance. So I'd say all those things together make it attractive to use, but it's still a very hard statute to prevail under. It. We'll get into this more, but it's a tough evidentiary showing. It's rare that you're going to have the type of case where you can nail all of these elements and really use it. But if you do have that rare case that fits into the statutory framework, it's a powerful tool.
Well, let's talk about the actual case. This is Painters and Allied Trades District Council 82 Healthcare Fund versus Takeda. For listeners not familiar with the case, can you give a brief summary?
I'll try my best to keep it brief because it's a very a long saga, this litigation. But So this case concerns a drug called Actos. It's generically pioglitazone. And Actos is a diabetes drug. It was developed originally by Takeda Pharmaceuticals. They're a Japanese pharma company, and they partnered with the largest American drug company, Eli Lilly, to bring this to market. This was really Takeda's first big venture into the U.S. market, and so that they wanted to partner with an established U.S. company to do that. It came onto the market in 1999. It's a third line diabetes defense type of drug. So, if diet and exercise don't work, if metformin doesn't work, a doctor might consider Actos. The issue was from the get go, before this thing was even approved, the companies were aware of a bladder cancer risk with the product. I could go into detail about how they were. Let's just say there was some signals emerging for some animal studies. um, the drug still managed to get approved in 99. There was ongoing conversations with FDA about this bladder cancer risk pre and post approval, where that's really where the meat of the fraud comes in. They were aware that this was a serious issue, and they attempted to really downplay and minimize the risk and explain it away to the FDA, despite their repeated concerns. And this whole time, they were specifically aware of what a bladder cancer warning added to the label, the effect that would have on their sales. They were conducting internal physician marketing surveys where they were using hypothetical drug products that were essentially identical to Actos and pulling physicians and saying like, hey, if we were to add a bladder cancer warning to this, how would this affect your prescribing? And, remarkably, what they were hearing was it was going to decline precipitously. So long story short, FDA eventually forced Takeda to add a bladder cancer warning to the drug in 2011. Sales tanked after that. It's still on the market, but it still has the bladder cancer warning. This case was originally part of a multi-district litigation filed in the Western District of Louisiana. This case was originally filed in like 2013 or 2014. It's been going on for a while. The MDL, that's the multi-district litigation. There was a big part of that was obviously the personal injury litigation, where patients that were taking this drug for years that ended up getting bladder cancer that were alleging that their use of the drug was a substantial factor in them getting bladder cancer. There was a big trial in the MDL for one of these cases that resulted in a $9 billion punitive damage verdict against Takeda and Lilly, specifically for the sort of ongoing, intentional misconduct in kind of misleading the public about the risks of this drug. The court obviously reduced that. It's rare that you uphold a punitive damages award like that in court, but that ended up, leading to a settlement for the personal injury cases. But for the fraud cases and the economic injury cases like this, those were then, at least this case was transferred to California in 2017. So what is this case? How is it different from the personal injury cases? This is a class action. We have a class representative that is a labor union health fund that paid for Actos over the years for their union members. And they are the class representative for a national third-party payer class. And the class alleges that but for Takeda and Lilly's fraud in concealing a material risk of bladder cancer, that all of these entities, all of these third-party payers that were paying for the drug for years, if the bladder cancer risk were disclosed, they would not have paid for this drug in as much quantity as they ended up doing because of the fraud. So it's basically a pure economic injury case where the third-party payers are alleging, we spent way more on this than we would have because of your fraud. that is the case in a nutshell. It's distinct from the personal injury cases because it purely focuses on the economic harm that the entities that were paying for this drug suffered.
And what are the allegations that elevate this to a RICO?
Um, I'd say the main thing here that you don't see in a lot of like standard fraud cases is the enterprise element. It's that coordinated conduct amongst distinct actors operating with a shared purpose. So here you really do have that. You have two separate corporate entities, Takeda and Lilly, that they entered into this long-term commercial alliance to develop and market and sell the drug. But I mean, their coordination extended to decision making about how safety information would be generated, framed, and communicated to physicians, regulators, and the broader medical community. So you really have that distinct enterprise here between the two companies that engaged in concerted fraudulent conduct. Um, that really makes this a good vehicle for RICO that you just frankly don't see in a lot of other cases involving pharmaceutical fraud.
One hurdle in civil RICO is what's known as proximate cause. Can you explain what that means in this context and how your team persuaded the Ninth Circuit that third party payers and patients could show direct injury despite physicians standing in the middle of the prescribing decision?
Absolutely. So that's a good question. And it ties back into the history of this case a little bit. When this case came out of the MDL and was transferred to a California district court, the original district court judge dismissed the case on this particular issue. We then appealed it to the Ninth Circuit in 2018. And the Ninth Circuit reversed the district court and held in our favor on this element of proximate causation under RICO. Now, what does that mean? It means that in civil RICO, you have this requirement of proximate causation that's really about directness. It's the statute requires that the injury be caused by reason of the racketeering conduct, and so that means that there has to be some sort of a direct relationship between the misconduct and the injury. So defendants, in these types of cases, they like to argue that, well, you have physicians here that are standing in the middle of the prescribing decision and that their independent medical judgment breaks the causal chain between any misconduct and the payments that are made by your third party payers or by your patients. And here in this case, the Ninth Circuit rejected that framing. What they did was they explained that physicians are foreseeable intermediaries. They're not independent intervening causes. So, because it's a prescription drug, the defendants necessarily knew that physicians were going to be involved in the process, and they knew that they don't pay for the drugs that they prescribe. The economic injury here only occurs when the patients and the payers actually purchase the prescriptions. So, that end goal, that ultimate payment, it's not incidental. It's how the system works. So the court rejected that framing and recognized the core nature of the economic injury here under civil RICO.
The case has been described as the first national civil RICO class action certified against a major pharmaceutical company. What makes this case so significant?
It's a good question. There have been cases before that have tried to certify this as a class action, and those cases have failed. Basically, what that means to certify a case as a class action. A class action is it's you use a class representative who kind of stands in on behalf of a group of plaintiffs, individuals or entities that are similarly situated, that are they share the same injury by the conduct at question here, and it allows you to group all of these claims together and litigate it in a central vehicle. So when you get a class certified, that's essentially the judge signing off on this to be able to proceed in an aggregate fashion. um, why I think it's significant and why this case kind of stands out It involves a single drug. It involves a coherent theory of economic injury that's tied to the prescription volume. And critically, and why I think this one succeeded and others hadn't in the past, is that the evidence is very strong here. I mean, we have a robust econometric regression analysis. There's tons of internal company materials that bear out injury. There's a bunch of peer-reviewed economic literature on the effect of the labeling on prescribing. Um, so I think it just stands out on the strength of the factual record, which actually signals, this isn't opening the floodgates of litigation for these types of cases. But it also signals that pharmaceutical companies aren't categorically exempt from civil RICO scrutiny when the elements of the statute are satisfied.
Many prior pharma cases have focused on failure to warn, consumer protection statutes, or false claim act theories. What's novel about deploying RICO as the central framework in a nationwide class action over an FDA approved drug?
I think you hit the nail on the head when you mentioned the nationwide scope there. RICO is very useful in addressing that sort of like nationwide, market-wide scheme. Whereas traditional failure to warn and consumer protection claims, they tend to be more, or they can be more state law driven and individualized. So I'd say, again, here, RICO's useful in addressing those very organized, sustained schemes over time. It's also useful in addressing purely economic injury that's caused by market distortion, which is what you have going on here with the kind of fraud in omitting the bladder cancer information. So again, if you have the facts to meet the elements of the statute, it's a good way to get at this sort of unique fraud that isn't captured by some of the other types of legal regimes that are also commonly used.
The Ninth Circuit not only allowed the RICO claims to proceed, but also affirmed class certification. What aspects of the court's reasoning do you think are the most significant for future RICO cases against pharmaceutical manufacturers?
I'd say that the court really strictly adhered to Rule 23, which is the rule of federal civil procedure that governs class actions, and Supreme Court precedent, and very faithfully followed existing law. I'd say there were three main points that the Ninth Circuit hit that will be useful in kind of guiding the discussion, for future cases. The first one being that the court reaffirmed that class certification in these types of cases turns on whether the elements of injury and causation are capable of proof through common evidence. What that means, common evidence, it's evidence that any given member in this class, any given third party payer could use to meet the elements that they need to meet under the statute. It would be stuff like, the regression analysis that I mentioned. It would be stuff like the internal company documents. It would be stuff like the peer reviewed literature. Those aren't individual in any way to any specific class member. Any random third party payer of the thousands in the class could point to that same information and use that to prove their case. So when the common evidence that you can use and the common issues predominate over kind of individualized defenses, that's when courts say this can proceed as a class. So the Ninth Circuit kind of stood by that. It also addressed the issue of uninjured class members, and this is a big issue that is the Supreme Court has signaled some interest in, is whether a court can certify a class if there is some known number of uninjured class members in it. Here, we don't really have that issue because by virtue of the class definition, it essentially guarantees that all of the third party payers are injured. But the court did reiterate that, if there is a de minimis or even a slightly more than de minimis number of uninjured class members in the class definition, that's not going to stop a court from certifying the class. And then lastly, the court, reaffirmed that physician prescribing decisions don't categorically defeat class-wide proof of causation. I'd say those are the three main points that I took from the Ninth Circuit decision.
And why focus the RICO case on economic harm to payers rather than on personal injury claims by patients who develop bladder cancer?
Um, I mean that's kind of that's the nature of the statute. You kind of are necessary, like if you are going to bring a RICO case, you're necessarily limited to looking at the economic injury. And again, as I was discussing a little bit with the prior multi-district litigation, there were certainly other cases out there where people were bringing the personal injury cases for people that got bladder cancer. Um, so that was definitely another viable pathway for trying to get some justice from these companies that did really engage in some pretty egregious conduct with respect to suppressing the bladder cancer risk with this drug. So again, if you are going to bring a civil RICO case, you need to figure out a way to make sure you're hitting on a economic injury specifically.
We talked a bit about some of the advantages plaintiffs have in bringing a RICO case or some of the incentives for doing that. But how does that change your evidentiary burden compared with a standard negligence or strict liability pharmaceutical case?
That's a really good question. I'd say the biggest hurdle you have to overcome that you don't need to prove in those types of cases that you mentioned is the intentional misconduct, the intent. Um, that's hard to prove. It can be very hard to prove. It has to be very, very strong, the fraud, to really get at that element. So that is one thing that really sets RICO apart and makes it imposes a way higher burden in some respects than just, negligence or strict liability. And the other things are things that we've discussed briefly earlier. That enterprise element. You're not going to always have that present in a set of facts involving fraud. Um, Also, that pattern of racketeering activity element. That's another one that you're not always going to see elsewhere. So, putting all of that together, it's kind of a unique package of elements that you have to hit that aren't all present in negligence or strict liability.
You mentioned the case has been litigated already for more than a decade. Where does it stand today procedurally, and what timing do you anticipate for trial?
Yeah, so that's also a good question. So after that 2018 or Ninth Circuit appeal that I mentioned, where we ended up reversing the district court on proximate causation, it was sent back down to the district court. We then got a new judge at that point, Judge Holcomb, in the Central District of California. We moved for class certification in 2021, and the national third party payer RICO class was certified in 2023. The defendants after that, they took they took an appeal this time, and they appealed the class certification order to the Ninth Circuit. We finally last year got the order from the Ninth Circuit where they affirmed class certification. And so now we're back in the district court. Defendants are trying to appeal it again. They just filed what's called a writ of certiorari to try to take the case up to the Supreme Court. Our brief in opposition opposing that is due on Monday, actually. So I've been working on that over the past couple of weeks. They also filed a motion to essentially what's called a summary judgment motion to dismiss the case on another legal issue. So we're litigating the case actively in the district court. We're gonna fight out this legal challenge that they're bringing, and we're hopeful that the Supreme Court isn't going to take this thing up. If you want, I can sketch out the issues that they're trying to raise at the Supreme Court level and why I don't think the Supreme Court will take it up or should take it up. And assuming that the Supreme Court doesn't take it up, and assuming that we win on this challenge, this other challenge that they're bringing, I think realistically we'd be looking at a trial date sometime next year. That would certainly be the hope.
And what is the challenge?
So a petition for a writ of certiorari to bring something up to the Supreme Court, if it's not like a hot button constitutional issue or like a dispute between two different states that are like, the types of classic things that the Supreme Court likes to hear, another classic thing that they like to hear is when there is what's called a circuit split, when you have different appellate courts that are coming out different ways on a legal issue, or applying different legal rules in similar scenarios. And so they tried to raise two circuit splits that they say warrant the Supreme Court to kind of sort these things out amongst the federal appeals courts. The first one is on that issue of uninjured class members. They try to say that, number one, there is a circuit split between certain courts on whether you can certify a class with uninjured class members. They say the Ninth Circuit falls into one side of this divide in saying that you can do that. And they say there's other courts that say you can't certify a class if there's any uninjured class members in it. Our main argument against that is there aren't any uninjured class members in this class, this particular case. They haven't identified one, and they're probably not going to be able to do so because the likelihood that any of these class members are uninjured is probably infinitesimal, just based off the probabilities. So like our first argument is this is not a good vehicle for the court to consider this issue because it's not actually an issue that is present in this case. The other issue that they raise is they say that there's a circuit split amongst the kind of the reliance issue and the kind of the physician prescribing decisions severing the causal chain and prohibiting a third party civil RICO class from proceeding in the manner that we did. The only issue that they run into there is that there's not really, as we'll argue in the briefing, is that there's not actually a circuit split on that question. And I think we'll win the day on that argument. So I don't think the Supreme Court should take it up, given what I just explained, but we'll see what happens.
You talked about this not necessarily opening the door to a flood of civil RICO cases against pharmaceutical companies, that there were unique elements here. But what message does this case send to the broader biopharma industry about the legal risk of suppressing or minimizing emerging safety signals for blockbuster drugs?
Yeah, that's a good question. I think the message is it's a careful and it's a nuanced one. It's not a blunt warning. I'd say that, look, like this case doesn't suggest that companies are going to face RICO liability for good faith scientific disagreement, for evolving data, or for difficult judgment calls about emerging risk. I mean, those are inevitable. They're expected in any sort of drug development and life cycle management. I say what the case does underscore, though, is that how these companies respond to emerging safety signals, that matters, and particularly when internal data, internal analyses, and internal communications are beginning to diverge from what is actually being conveyed externally. So courts are drawing a line between managing scientific uncertainty on the one hand and systematically suppressing, reframing, and minimizing material safety information to protect sales on the other. So I think this signals that what's really key here is the intent, in the way you go about doing pharmacovigilance. It should not be subservient to marketing, and there's a good faith way to do pharma, and clearly what these companies did in this case is not that, and it's a signal that you really need to take this seriously.
Some industry groups have warned that RICO exposure could chill innovation or discourage companies from candidly analyzing safety signals. How do you answer those concerns? And where do you think the line lies between legitimate risk benefit debate and actionable fraud?
Yeah, that's a really good question, and I'd come back to what I said about, like, I'd say the line really turns on intent and conduct rather than the outcome. So, like, a legitimate risk benefit debate that involves grappling with incomplete data and testing hypotheses and revising views and, communicating uncertainty in a way that allows regulators and physicians to exercise independent judgment. That's totally fine. That's how the process should be. But what moves a case into RICO territory is, again, when those internal analyses identify material safety risks, but then those risks are, systematically suppressed or selectively disclosed through coordinated communications designed to protect sales. That's really the line. Is like, what are you operating in good faith, and are you transparently disclosing what you're finding, or are you massaging the data in a way to mislead regulators to protect your bottom line? That's really what it turns on. And so I don't think it should chill good faith, science. Like, if you are operating, in a transparent manner, you have nothing to worry about.
If you succeed at trial and obtain a verdict with trebling that could exceed an estimated $7 billion, how do you expect that to affect how drug manufacturers approach pharmacovigilance, labeling negotiations with FDA, and their internal documentation practices?
Yeah, I think it's important to start by saying that obviously the 7 billion, I mean, that's a lot of money. It's a big number. But by saying that, the size of a potential verdict isn't the goal itself, I'd say the significance of a big verdict, if one were to occur, would be, again, what it signals about accountability when there is that strong evidence of sustained coordinated misconduct. I mean, these are two companies that made a collective profit of, I believe, during the what we define as the class period, the damages period, over $24 billion through engaging in fraud. So, again, with respect to, I'd say, pharmacovigilance, I'd say the message would be that the early signals matter, even when they're inconvenient or maybe not fully understood. You need to get to the bottom of it, and you need to be transparent with what you're finding. And on labeling negotiations, you mentioned that, with the FDA, I'd say that the takeaway again is credibility and consistency and transparency and good faith engagement with the FDA is critical, and is the main thing. And then for, like, internal documentation purposes, I mean, we'll see what happens, but I really hope the message that companies take away from this is not, write less or avoid analysis, but, exactly the opposite of that. I'd hope to see better governance around documentation, clear records showing that safety concerns were debated openly and that dissenting views are considered and that the decisions are actually grounded in patient welfare, in regulatory obligations rather than, preserving revenue. But we'll see what happens.
And what do you think this means for institutional payers, health plans, union funds, PBMs, who may now see RICO as a viable tool to recover payments tied to allegedly fraudulent drug promotion?
Yeah, that's a very good question, and something I'm still thinking about because, like, historically, the payers, I guess I'm talking more on the, the union fund and health plan front rather than the PBM front. As I guess, the plans in the union funds are often using PBMs to, manage their formularies and whatnot. But historically, these payers have often absorbed the economic consequences of fraudulent drug promotion without a clear path to recovery. And I think this does give a clear path, again, with all the caveats and limitations that I expressed earlier about why RICO cases are hard. But I think there's a practical takeaway for payers, and it's less about litigation, more about how they do business and how they do governance, which is, they're already collecting extensive claims and utilization data, you know, and cases like this show that data can be used to assess whether prescribing patterns were materially affected by misinformation. So it reinforces the importance of payers engaging actively with safety information, with formulary decisions, rather than assuming that regulatory approval alone insulates them from economic harm. So, I hope it provides a pathway forward to kind of redress a type of, an injury that you don't frequently see a recovery on. I mean, if you do have a clear proven fraud and you know how much companies are profiting from that fraud, there's a big delta there. And this is assuming the facts are there to support it, a way for the entities that actually bore the brunt of the fraud, economically speaking, to recover some of what they lost.
Harrison James, Senior Associate Attorney at Wisner Baum. Harrison, thanks so much for your time today.
Thank you. I really appreciate it.
Thanks for listening. The Bio Report is a production of the Levine Media Group. To automatically download this podcast each week, subscribe to our RSS feed or through iTunes or other podcast manager. To join our mailing list, go to levinemediagroup.com. We'd love to hear from you. If you want to drop us a line or are interested in sponsoring this podcast, send an email to danny@levinemediagroup.com. Special thanks to Jonah Levine, who composed our theme music, and the Jonah Levine Collective, which performs it.